Okay, it's 11 o'clock, so I think we'll kick off our webinar today. So first of all, just like to welcome you all to today's webinar. This is the first in a series of webinars that we're going to be doing on the Patient Safety Notifiable Incidents and Open Disclosure Act 2023. So you're all very welcome today. My name is Angela Teisel. I'm the lead for Open Disclosure in the HSE, and I'm the manager of the National Open Disclosure Office. And I'm joined by some of my colleagues, who I'll introduce in a moment to you. Just a few housekeeping things around our webinar today, just to say that the session is being recorded and you can leave your video turned off and remain muted throughout the webinar. And you can listen to the webinar over the computer, but if you do have any sound problems, you can dial in and the number there is on the screen and it'll be in the chat there for you as well. Just to say that these webinars do have CPD credits. The RCPI accreditation at this moment is pending, and we hope to have that very shortly. There are 2 CAUs from the Nurse and Midwifery Board of Ireland, and these apply to attending the live webinar. So it doesn't apply to actually downloading the recording and playing the recording back. So you must have attended the webinar today online. If you want a certificate, you can contact the National Open Disclosure Office and we'll send that cert out to you. So email opendisclosure.office@hse.ie. Today, we're delighted to have 2 ISL interpreters with us, Michael Feeney and Ciara Flatley. And if you do need the assistance of the interpreters throughout the webinar, just hover over the video of the interpreter, click on the 3 little dots over the interpreter's video and click on Move to Stage, and then you'll be able to see. And you can do that for both of the interpreters because they will be taking turns throughout the webinar presentation. In addition to this, there are closed captions available, and this is text that will appear on your screen to reflect what has been said by the presenter during the webinar. And to enable this function on your device, please click on Show Captions. You see that on the left-hand side, the lower left-hand corner of your screen. Just click on that and you can enable that for yourself. So our presenters today are our colleagues from the HSE and HSE Funded Services Implementation Working Group for the Patient Safety Act. And that's a national work group that's been set up to oversee and manage the implementation of this Act across HSE and HSE Funded Services. So we're delighted to have Colette Brett, Head of Quality, Safety and Risk from the National Screening Service, Majella Daly, Assistant National Director, National Centre for Clinical Audit, Lorraine Schwamberg, Assistant National Director for Incident Management in the National Quality and Patient Safety Directorate, and myself, who works with Lorraine in the Incident Management Open Disclosure team in the National Quality and Patient Safety Directorate. So I'm going to hand you over now to Lorraine, who's going to start off our presentation today. So I'll catch up with you shortly.
Hi everyone. Thank you, Angela, for the introduction. I think the slides should be sharing now. Can you see those okay?
Yeah, all good, Lorraine, yeah.
Thank you. Yeah, so as Angela said, I'm the A&D QPSIM, which covers incident management, open disclosure, and the NIMS system. So I'll touch on a number of those areas as the presentation will go on. I'm the HSE lead for the Patient Safety Act implementation. So I'm going to start off with giving you an introduction and oversight of the legislation, and then my colleagues will go into different aspects into more detail. So today, Angela will take you through specifically the open disclosure requirements around notifiable incidents, and the requirements around reporting to the regulator, and some of the penalties that the legislation outline within it. Then Colette will talk through the Part 5 patient requested screening reviews, and Majella will talk through some of the provisions in relation to clinical audit that are captured within the legislation, and I will touch on some of the reporting requirements specifically through the NIMS system and the changes that are afoot with regards to that. So you can see the legislation covers on a few different areas and brings them together. Overarchingly, the purpose of the Act is to ensure and support and further embed that there's openness and transparency within the wider healthcare system. So the Act, it seeks to establish a number of requirements. So it will be mandatory to undertake open disclosure. in particular in relation to 13 notifiable incidents. Sometimes you'll hear us talking about 14. That's because the last one has an A and B section to it, and I will talk you through those in a few minutes. The Act specifically requires organisations to notify the incidents to the regulators, and hence they are called notifiable incidents. And the organisations that we would be reporting them to are HICWA, the Chief Inspector, and the Mental Health Commission. The Act provides legal protections in relation to the information that's being shared, and Angela is going to touch on that in a bit more detail. It touches on procedures in respect of clinical audit and the data obtained as part of clinical audits. It makes amendments to the Health Act in relation to HICWA, the Health Act 2007, and provides for the application of standards set by HICWA to private hospitals. And the Act further reviews, gives further powers to the Chief Inspector to review certain incidents. And lastly, it provides for the mandatory open disclosure by health service providers of reviews carried out in relation to cancer screening. And Colette will explain that a little bit further, how that is linked to that particular area. So the Act itself, it's split into 9 parts, and as my colleagues go through their presentations, they will highlight where you find the different elements. But just to give you a general overview, the Part 1 is very much the introductory piece that provides you with some of the definitions that would become relevant, in particular when you look at the notifiable incidents, in particular what's meant by health service provider. Then importantly, Part 2, which Angela would focus on, is around the actual open disclosure requirements around the notifiable incidents. The Part 3, the procedure for making open disclosure of a notifiable incident. Part 4 is then actually the reporting to the regulator, which I will come back to at the end with regards to NIMS. Part 5, Colette will focus on and explain in more detail as it relates to cancer screening services, and Majella, as I mentioned, will focus on clinical audit. Just to highlight, we won't go into it in a lot of detail, but just so that everybody is aware, the Act obviously covers the wider healthcare system. So in particular for the regulator, as I mentioned just a few minutes ago, it increases some of their authorities and it expands it to private hospitals, and there can be specific reviews requested by the Minister of Health, the Minister for Children, and we are in collaboration, or certainly in good communication with our regulator colleagues, and they will be providing guidance around the expectations around these as well, as we're all gearing up towards implementation of the Act. And then lastly, Part 8, which Angela will cover again, is around some of the issues that might occur where there might be non-compliance. And then in Part 9, there's some miscellaneous, I suppose, areas to cover. For instance, it highlights that the Act will be reviewed 2 years after commencement by the Minister and review some of the requirements of the legislation, which is positive, certainly. And it captures some of the other legal amendments that are being made to other legislation, and I will highlight the ones in particular in relation to the National Treasury Management Agency Amendment Act 2000. Then importantly, right at the back of the legislation, and Kelly will have shared the link to the actual legislation, is Schedule 1, and that provides us with the list of the notifiable incidents. And this is obviously, you would hear us speak quite a bit about that, in particular Angela and myself, as to what the notifiable incidents are. So as I mentioned, there will be the mandatory requirement to report them to the regulator and to undertake the open disclosure steps as described in the legislation. This is how they are described within the Act in Schedule 1. So they are a very succinct list. We have within the HSE and the wider implementation group, but we also have a work stream that's particularly focusing in on these. And we will be developing guidance for staff. So by the time commencement comes, we will have examples of what the interpretations will mean to help staff in identifying what the notifiable incident is. You'll see notifiable incidents 1.1 to 1.4 are very much surgery related in some jurisdictions called never events, very much aligned to some of the SREs that we have. So where there is surgery performed on the wrong patient, on the wrong site, where there was a wrong surgical procedure, or there was an unintended retention of a foreign object. But I suppose just a word of warning with regards to these, they do all have quite significant outcomes in that there would have been a patient death associated with those notifiable incidents. 1.5 is again surgery related. So it describes the requirement to report as a notifiable incident where there was the unintended or unanticipated death occurring of an otherwise healthy patient undergoing elective surgery, where the death wasn't attributable to the underlying disease. Then 1.6, it captures more kind of medical fields and relatively broad. It applies to any unintended and unanticipated death occurring in any place or premises in which health service providers provide a health service that is directly to any medical treatment, and the death did not arise from or was a consequence or wholly attributed to the illness of the patient. So again, that's relatively broad, but certainly the outcome for the patient, sadly, would be death. Then moving over to the right of the slide, one of the notifiable incident 1.7 is related to any incident where there was a patient death following a transfusion incident of an ABO incompatible blood or blood component. 1.8, where there was a patient death associated with a medication error and the death was unintended and unanticipated, as it did not arise from or was a consequence attributed to the illness of the patient. 1.9, so a number of the next ones really can hone in on the maternity area. 1.9 is where there was an unanticipated death of a woman while pregnant or within 42 days of the end of the pregnancy from any cause related to or aggravated by the management of the pregnancy, which did not arise from or was a consequence of the illness of the patient or underlying condition of the patient. Then 1.10 and 1.11, again, very much with the maternity lens. 1.10, where there was an unanticipated and unintended stillborn child, where the child was born without a fatal fetal abnormality. And then it outlines that it needs to be linked to prescribed birth weight, prescribed gestational age, and it wasn't directly linked to any underlying illness. So again, we're working with our colleagues in NWIP and maternity services to provide services with guidance as to how these will be interpreted, what is meant by prescribed birth weight, prescribed gestational age. Then 1.11 is an unanticipated and unintended perinatal death where a child born with or having achieved a prescribed gestational age and prescribed birth weight who was alive at the onset care and labour from any cause related to or aggravated by the management of the pregnancy, and the death did not arise from or was a consequence of the illness of the child. So apologies again, I know these are very hard-hitting list of incidents, notifiable incidents to open the presentation with, but they are important because a lot of the focus of the legislation is on these incidents, on these notifiable incidents. 1.12, an unintended death where the cause is believed to be the suicide of a patient while being cared for in or at a place or premises in which a health service provider provides a health service, whether or not the death was anticipated or arose from, or was wholly or partially attributed to the underlying illness. And then 2.1 relates, so this is where there's not necessarily a death of the patient, but there is a consideration of the treatment for the patient. So 2.1 is where baby who in the clinical judgment of the treating health practitioner requires or is referred for therapeutic hypothermia or has been considered for but did not undergo therapeutic hypothermia, as in the clinical judgment of the health practitioner, such therapy was contraindicated due to the severity of the presenting condition. So some of these are a bit more straightforward than others, and as I mentioned, there will be guidance available with some examples for our staff. We're already engaging with our colleagues from the Department of Health around the interpretation of these. Certainly without giving away too much, I know that there will be certainly guidance as to what is meant with regards to health service provider facility. So where there was a suicide, does that involve the patient's home, and so forth? That will be more narrow, and that will be more implementable, I suppose, for services to apply. And then also looking at other elements, what's meant by surgery. So how broad is that spectrum? That will likely include interventional procedures and that as well. So that guidance will be available, and any questions and feedback, we welcome that in the chat as well, because that will inform some of that guidance development piece as well. And I'm going to hand over to Angela now to take you through the next few pieces. And I'm still going to be moving the slides. So Angela, prompt me if I'm not moving at your speed.
Okay, that's great, Lorraine. Thanks very much for that. So as Lorraine said, I'm just going to hopefully sequentially take you through the open disclosure of a notifiable incident under the Act, the procedure for managing that open disclosure, and the notification to the regulatory bodies, as Lorraine mentioned already. And then just moving on, Lorraine, we're just going to look at then the offences, penalties and offences for non-compliance with the various sections of the Act. So quite a bit to get through. So we'll probably just move on to the next slide there, Lorraine, and I'll talk to you about the responsibility. So first of all, when we think about a notifiable incident has occurred, so the first thing is that the health practitioner must inform the health service provider of that notifiable incident as soon as possible. And it's really as if it's in their opinion or they suspect that notifiable incident has occurred. So as Lorraine has pointed out, a lot of notifiable incidents are the first 12 relate to the death of a patient. So the threshold here won't be to await a coroner's report, but rather that there will be an element of clinical judgment. So if you suspect, or if it's of your opinion that this may be notifiable instance, that then you'll manage it as a notifiable incident and do the open disclosure and then do the notification to the regulator. And if that notifiable incident has happened while the patient was under the care of another health service provider, it is the responsibility of the service who has actually identified that notifiable incident has occurred to make sure that open disclosure has happened. And that we'll be doing some guidance around that piece, because obviously if the care was provided by another service, there will be a need to get in contact with that service and discuss together how that open disclosure will be managed, because you won't have the detail of the service provided by the other health services provider. Then moving on then to the requirement to notify to the regulator, and that's part 4 of the Act. So the health service provider must notify the relevant regulator as soon as practicable and no later than 7 days from when the health service provider was satisfied that notifiable incident occurred in the course of the provision of the health service to that patient. And the regulators, as Lorraine already said, are the Mental Health Commission, HICWA, and the Chief Inspector. The regulator then must acknowledge in writing to the health service provider no later than 21 days that they have received that notification. And that's 21 days following receipt. What information has to be provided to the regulator includes the name of the health service provider, the identification of the type of incident, the date the incident occurred, the date the incident became known to the health services provider, actions taken or planned in response to the notifiable incident to try to prevent a recurrence or mitigate the consequences of a similar incident should it reoccur going forward. And then a statement of the actions taken or planned for the purpose of sharing learning. So they're all the elements that will be required to be notified to the regulator. So if we ask ourselves, and these are things you need to consider yourself in relation to your service, how will the healthcare practitioner notify the health service provider that notifiable incident has occurred? And we're going to be doing a bit of work just in collaboration with acute and community service, how that might look like. Obviously, this will have to go onto the NIMS system at some stage and be notified through that, but it's really important that the health service provider is notified as soon as possible after that incident has been recognised. Then how will notification to the authority be managed? And again, that's going to be done through the NIMS system, and Lorraine's going to talk to that a bit later on when she covers the section on NIMS. But there is a national working group with the Department of Health, State Claims Agency, HSE and the regulators looking at how those notifications will be managed through that NIMS system. And then another question to ask yourself in relation to your services: who will be responsible for making that notification to the regulator? And again, we'll be doing some collaboration with Acute and Community Service to hopefully provide some guidance to you about how or who will make that notification. So just moving on. Moving on now to the management of the open disclosure of a notifiable incident. And really, as we go through this process, you will see that this process, or a lot of it, aligns very nicely with our current HSE Open Disclosure policy. So to start off with, who makes the open disclosure? And generally, as is with our policy, the patient's principal healthcare practitioner or another healthcare practitioner deemed suitable if that principal is not available or is unable to make that disclosure. Who is the open disclosure made to? And again, the open disclosure, and again, for these set of circumstances, for the first 12, it will be to the relevant person because the patient is deceased. But in general, because the Minister has actually, he's actually retained the right to add to this list of notifiable incidents at any stage going forward. So generally, the open disclosure can be made to the patient, the relevant person, or the patient and relevant person together. When should the open disclosure be made? And again, that's the timing of it. And really, it's as soon as practicable and is deemed appropriate by the health service provider. And it's not necessary to know all of the information pertaining to that incident to initiate this meeting. And again, that's the same as our open disclosure policy at the moment. You don't need to know all the information around the incident to start that open communication process with the patient, and in the case of these incidents, the family of that patient or relevant person. Preparing for that open disclosure, it's important that there's an assessment made of all the circumstances and nature of the incident, that you consult with any person as appropriate, consider who the open disclosure will be made to, determine in advance the apology to be made to that patient or relevant person, and consider how the information can be relayed in a manner that is clear and understandable to that or those individuals. Preparation for open disclosure again, and really importantly, and again in line with our open disclosure policy, is the appointment of a designated person. So now there is a legal requirement that there is a person designated to liaise with the patient and or the relevant person to assist them in preparing for and attending an open disclosure meeting. And they will be liaising over and back between the patient, family and the service, and identifying, any issues, clarifications that the patient or family have that might need to be addressed at that open disclosure meeting. And on the day, meeting and greeting the family, taking them to the room where the open disclosure meeting is happening, and just caring for them throughout that open disclosure meeting. This designation must be made in writing and kept on record by the health service provider. And again, as I said, this is such an important role in relation to the possible or potential outcome of this meeting for the relevant person, as I said, in most of these circumstances. How that open disclosure is made, and again, in line with our open disclosure policy, generally this open disclosure meeting will be held in person with the patient, relevant person, or patient and relevant person. So the patient can, or the relevant person can request to have the meeting other than in person, and this request can be an oral request coming from them. So they might want a telephone conversation or a virtual meeting. And again, if the patient does request this or the relevant person, this request must be recorded in writing by the health service provider and kept on record. So then just looking at the actual management of the open disclosure meeting itself, and the Act is very clear about the information that must be provided to the patient or relevant person at this meeting. And it includes the introduction and the names of the persons present at the open disclosure meeting, a description of the incident that has occurred, including the date of the incident where that is known, when and how the health service provider became aware of the incident, and if the health service provider is aware of any physical or psychological harm as a result of that incident. Now, acknowledging that predominantly from the current list of notifiable incidents, the patient is deceased. So again, just in consideration that there may be different notifiable incidents added to this list, where the health service provider believes that harm has already occurred, be it physical or psychological harm, that it will be discussed how that has been treated clinically, or what care has been put in place for the patient. And also where the health service provider is of the opinion that there could be further physical or psychological harm to the patient going forward, that is actually discussed with the patient or relevant person. An apology then is determined by the provider and is relevant to the notifiable incident that has occurred. So it's really important in advance of this meeting for the team to discuss what is the apology that they need to provide to that patient or that relevant person, the details of it, and how it will be delivered. And then the actions that the provider has taken or proposed to take, and the procedures or processes that has to be implemented in order to address the learning or the knowledge the provider has obtained from its consideration of the incident and the circumstances giving rise to it. So again, that will come into your review process and the learning and actions and recommendations taken. Now, in relation to the open disclosure meeting, it's important that a record of that open disclosure meeting is referred to as a written statement in the legislation, but this is the record. Again, this is something that our current policy requires, that after a formal open disclosure meeting, that there is a record of the meeting provided to the patient or relevant person, or patient and relevant person where both have been at the meeting. So that can be given at the open disclosure meeting or within 5 days of the meeting happening. And that is not 5 working days, that is 5 days. So this is really important to remember that, because that is something we don't have specified in our open disclosure policy. We have the record goes out, but we don't specify a time period for it, as we say, as soon as possible. The written statement or record must include the information provided at the open disclosure meeting. So all of the things I talked about in the previous slide, the information around that has to be included in that written statement. The written statement must include the details of any apology provided. It must state that the open disclosure was made pursuant to and in compliance with sections 5(1) of the Act. This written statement or record must be signed by the principal healthcare practitioner and also must be kept on record by the health services provider. So really important, and we obviously in open disclosure, we encourage really good record keeping anyway, and that note or record of that meeting is really important that is sent out to the patient for all open disclosure, and not only the notified incidents. So the Act does allow for the patient or relevant person to refuse to participate in an open disclosure meeting. Okay, and basically, if a patient doesn't want to attend an open disclosure meeting, they can authorize a relevant person to attend the meeting. And where perhaps that relevant person doesn't want to attend, the patient can then specify another relevant person to attend that meeting. And where an open disclosure meeting is refused by the patient or relevant person, they need to inform the health service provider that they will not attend the open disclosure meeting, and that they do not want to receive the information to be provided at this meeting, and they do not want to receive any additional notifiable information or apology that may be made. So there are record keeping obligations around this. So the health service provider must set out a statement in writing to the patient, relevant person, or patient and relevant person, indicating their refusal to attend an open disclosure meeting and their right to make a later request up to 5 years after the date the meeting was refused. So at any time during that period of 5 years from the date of their initial refusal to attend, they have a right to come back and to make a later request to have an open disclosure meeting, and that meeting will then be held by the health service provider with that relevant person. And the patient or relevant person must be provided a copy of this statement, and then a copy of this is kept on record. The patient, just moving on, Lorraine, the patient does have a right to actually refuse to accept this written statement, setting out their indication that they don't want to attend the meeting. So if they do refuse to accept this statement, the health service provider must make a note of this refusal, outline the incident to be disclosed and the date of the incident, sign and date that note, and maintain that note on record. And as I said, that where the patient or relevant person makes a later request, then the health service provider will make a note of that request, and the person who made it keep this note on record, and then proceed to have a notifiable instant open disclosure meeting with that patient or relevant person or both. The Act also allows for failure to contact the patient or relevant person. And really, both of these are the two exemptions in the Act. So the refusal of the patient to engage in open disclosure or the failure to contact the patient. These are the only two exemptions in the Act around open disclosure. So in a situation where there's a failure to contact the patient or relevant person to actually make that open disclosure of the notifiable incident, the health service provider must take all reasonable steps to establish contact with that patient or relevant person and set out in writing the steps that are taken and also include the contact information. So they may be looking at the patient's record and the details that were given, the contact information for their relevant person, maybe next of kin, that term might be used in some current records. They may try to make contact through the patient's GP perhaps, or maybe other services that the patient is attending. So just really set out those reasonable steps that are taken to try and make contact with that patient or relevant person. Sign and date the statement, maintain a copy of the statement on record, and even while you can't contact the patient or relevant person, this notifiable incident must still be notified to the regulator. Where contact is established with this patient or relevant person at a later stage, then the health service provider should proceed then to hold a notifiable incident open disclosure meeting with the patient's relevant person's consent, obviously. So as we talk about open disclosure, we talk about open disclosure being a process. And while we have our first meeting with a patient or the relevant person to talk about the incident that we're discussing, then, as we said earlier, not all of that information might be available for that first meeting. So where additional information becomes available, that the health service provider then will proceed to have another open disclosure meeting, with that patient or relevant person going forward to provide that additional information. And also based on that additional information, just if that information does lead to us to suspect that there is further physical or psychological harm as a result, or likely or unlikely as a result of that, and where there is going to be a change in the care or treatment of that patient as a result of this information, then that is discussed with the patient or relevant person as well. Also, if there's any new apology that is required as a result of the additional information that has been obtained, and then also that the provider will provide information on the actions taken or that they propose to take, or any procedures and processes to be implemented, again, based on the additional information, just to actually show that there's learning and that actions are being taken to try to prevent recurrence going forward. And also following the additional information meeting, this meeting will be handled just the same as the original notifiable incident open disclosure meeting. There will also be a statement or record of this meeting that will be provided to the patient or relevant person at the meeting or within 5 days of the meeting happening. Moving on then, in relation to managing clarification requests. So the Act provides for the patient or relevant person to seek clarification, and this relates to clarification of information provided at a notifiable instant open disclosure meeting or additional information notifiable instant open disclosure meeting. This request should be submitted to the designated person, and the patient or relevant person may request that the clarification is made other than in person. So again, it could be a phone call, it could be a letter, it could be a virtual meeting, but it doesn't have to be an in-person meeting. The management of the clarification request by the health service provider. So this request, as I said, goes into the designated person. They will make a record of the clarification request in writing and include the date that the clarification request was received. The designated person will then inform the healthcare practitioner who conducted the open disclosure meeting and liaise with them in relation to providing a response to the clarification request. The healthcare practitioner who conducted the meeting or another practitioner deemed suitable, if that practitioner isn't available or isn't able to respond, they will provide a response to the clarification request, and this can be made orally, but also must be followed up with the response set out in writing to the designated person and to the patient or relevant person, and this response must be signed by the healthcare practitioner who's providing the response to the clarification. And again, all of these records must be kept on file by the health services provider. Now, you've heard me mention, as I've gone through the various parts of the open disclosure process, a number of elements around documentation. And just a list of them there. So I think we need to just keep in mind that the majority of the documentation will really be around the written record in relation to the open disclosure meeting and the additional open disclosure meetings. And the other things are, I suppose, the refusals will be quite unusual for people to refuse. It can happen, but again, we just need to let you know about all of these sections of the Act here. But the predominant thing to think about in documentation is really those written statements or records going out after the open disclosure meetings that are held with the patient, and also the need to do a formal designation in writing for the designated person. But all of the documentation requirements in this Act must be adhered to. And just that you know that we are currently working on the development of some templates to assist you with this, and various documentation templates and examples of kind of covering letters that can be sent out to the patient or family, and with that documentation template, because we want to make obviously that our communication is empathic and compassionate. So we're doing a lot of work, and we're working with patient groups at the moment as well, and the letters and templates are with them at the moment, and they're working on them for us to make them as user-friendly, as patient-friendly as possible, and that really we get a great sense of empathy and compassion in these communications. We're also currently considering how all these records are stored, and you'll see from the information I've given you previously that the health service provider has to keep all of these records on file in the organisation. So we're currently liaising with the State Claims Agency and various people around how those records might be stored going forward. Then moving on then to Part 8 of the Act, which is the offences and penalties. And this is where a person or health service provider who fails to comply without reasonable excuse, and that's really important, reasonable excuse, shall be guilty of an offence and shall be liable on summary conviction to a Class A fine. I think that's currently up to about €5,000, the Class A fine is. This failure to comply relates to failure to notify the relevant authority or regulatory body, which is sections 27, 28 and 29 of the Act, which is the Mental Health Commission, HIPAA, and the Chief Inspector. And then there are various failures to hold an open disclosure meeting or a Part 5 review meeting, which includes non-compliance to hold a notifiable incident open disclosure meeting, non-compliant to hold a notifiable incident open disclosure meeting, and the example I gave where initially the patient or family refuses the meeting and then at a later stage they come back and ask for that meeting. So if you don't hold that meeting with them, then that is an offence. Non-compliance to hold a notifiable incident open disclosure meeting where there was an initial challenge to contact the patient or relevant person and where contacts later established. So again, like I spoke to earlier, if you do make contact, you do need to go ahead and have an open disclosure meeting. Non-compliance to hold a Part 5 review, and Colette's going to be talking about the Part 5 review process in a moment. Non-compliance to hold a requested notifiable incident open disclosure meeting following initial refusal by the patient or relevant person, and that's actually with the Part 5s again. And then again with the Part 5 where there was an initial challenge to contact the patient or relevant person and contacts later established. If you don't have that Part 5 review meeting, it is an offence. And your defence will always be that you are able to demonstrate all of the reasonable efforts that were made to ensure compliance, and that's in section 77 of the Act. So just moving on, Lorraine, please. So built into the Patient Safety Act, as is in Part 4 of the Civil Liability Amendment Act, and it's important to say that Part 4 of the Civil Liability Amendment Act has been revised to align it with the Patient Safety Act, and the process that I just spoke to you in relation to the management open disclosure will be the same process for the Civil Liability Amendment Act and the legal protections that do apply when open disclosure is managed within the provisions of both Part 4 of the Act and Patient Safety Act, but there will be these legal protections. And what these legal protections are is that the information provided and any apology given at an open disclosure meeting should not constitute an express or implied admission of fault or liability in relation to the incident or any clinical negligence action arising from the incident, will not be admissible as evidence of fault or liability in court in relation to the incident or clinical negligence action arising from the incident, will not invalidate the indemnity or insurance cover of the health service provider. And then moving on to the fitness to practice protections, it shall not constitute express or implied admission of fault, professional misconduct, poor professional performance, or unfitness to practice, or other failure or omission in relation to any complaint made by the patient to a regulatory body subsequently, and shall not be admissible as evidence of the same. And it's important to say that these protections will be automatic and apply when open disclosure is managed in accordance with the provisions of the Act and the completion of documentation as set out in the Act. So really, when we think about open disclosure of a notifiable incident in relation to open disclosure of any other incident or a particular harm events, how does it change really? So we have our incident management framework, we have our open disclosure policy, we have the Patient Safety Act now as well. And I'll just highlight some of the differences for you now in relation to what is different about open disclosure under this legislative process as opposed to the HSE policy. And as I said earlier, the open disclosure process in the Act for notifiable incidents is closely aligned with the current HSE open disclosure policy for patient safety incidents. And there are some additional requirements under the legislation as follows, and I've already highlighted them, but I think it's important just to bring them together for you now, that there is the requirement to notify these instances to the regulatory body within 7 days from when the health service provider is satisfied that notifiable incident has occurred. There's a legal requirement for the appointment of a designated person, and that is to be that designation has to be made in writing. That there's a written statement or record of the meeting that goes out to the patient or relevant person at the meeting or within 5 days of the meeting happening. And again, we have clarified with the Department of Health, and that is 5 days, not 5 working days. And there also is the record-keeping legal requirements throughout all stages of the process. And again, for non-compliance, there are offences and penalties that do apply where there is no defence for that. So just some take-home message in relation to open disclosure. The HSE Open Disclosure Policy requires that all harm events are disclosed. And really, I mean, the essence is that this Patient Safety Act is building on our current HSE policy. But this provisions of this Act relate to the mandatory requirements to notify and disclose these set of notifiable incidents set out in the Act. And as I have said earlier, the Minister has reserved the right to add to that list at any time that they feel it needs to be applied at a later stage. The Minister reserves also the legal protections apply automatically when open disclosure is managed in accordance with the legislation. So you don't have to say, I'm seeking the legal protections of the Act. When you manage open disclosure in accordance with the Act, you will automatically have these legal protections applied. And just the essence is really important that we don't lose the essence of open disclosure, and that is the right thing to do. And it's really important that we do it right for all patient safety instances, and particularly where there's been harm to a patient. Empathy and compassion are key, and sometimes that can get a bit lost when we go into kind of, I suppose, very prescribed processes, but it's really important that we maintain that empathic and compassionate response to patients and their families. And open disclosure, when we manage it well, it really does assist emotional recovery for all those involved in or affected by patient safety incidents, and the protection of that second harm or compounded harm that we often hear patients and families talking about. The first harm being the incident that they have been involved in, and the second harm being the way that we have communicated with them, or manner that we communicate with them, or in fact that we haven't communicated with them at all. And that can lead to such additional harm for the patient. And also, the Act really drives the importance of good documentation of open disclosure, which is critical. And we really always in our training talk about the importance of documenting open disclosure on the National Incident Management System and the patient record, and that the records of the meetings of the formal open disclosure meetings, that they are sent out to patients and their relevant persons. I think that's the last slide, Lorraine, is it? Yeah. So I'm just going to hand over now to Colette from Screening Services, who's going to bring you through the Part 5 reviews. And thank you, everybody, for your attention. Thank you.
Thanks, Angela. I'm Colette Barrett, Head of Quality, Safety and Risk at the National Screening Service. And today I'm going to speak to Section 5 of the Patient Safety Act on behalf of the National Screening Service. Next slide. So Part 5 of the Act covers requests for cancer screening reviews, as highlighted there in the red. On the next slide, as Angela spoke about before, we've sought clarification from the Department of Health on 28 aspects of the Act in relation to Section 5. And as those clarifications were only recently received back, we're still currently reviewing them. There are some challenges regarding the language used in Section 5 of the Act, which may have the potential to cause confusion. So what does open disclosure of a Part 5 review mean? So the term Part 5 review means a patient-requested cancer screening review. When we talk about open disclosure, we're used to talking about open disclosure in the context of a patient safety incident or a notifiable incident. However, a patient-requested cancer review is not a notifiable incident and is not automatically a patient safety incident. So therefore, for clarity, we're using the term communication instead of open disclosure. So therefore, what we're talking about is communication of a patient-requested screening review. In the Act, there are similar sections and language used in respect to notifiable incidents and open disclosure and the review of screening, the Part 5 reviews, though there are two different events. While there are similarities in the grayed out that Angela's already spoke to about a meeting is offered, the information available at the meeting, what's in the statement, the information available regarding the process, a designated person is assigned, any additional support. There are major differences. Screening reviews is a retrospective review which is initiated by the patient, which can be requested months to years after their cancer screening. Compared to notifiable incidents, which are reactive to an incident that has happened and initiated by the health service as soon as possible after the incident is identified. Whereas screening reviews can result in identification of a patient safety incident in 1 to 5% of reviews requested, the same is not necessarily true for notifiable incidents. So while the language is and the sections are quite similar, they're actually two different events. Screening reviews are not new to the National Screening Service, and in the main, the processes that are already in place reflect what's in the Act. So just to summarise, a high-level overview of what is in the Act is summarised in this flowchart of the requirements of the Act in regarding to patient-requested screening reviews. So the review for screening is received in writing. A designated person is assigned who would liaise with the person and outline the process and the timelines. Eligibility is confirmed for the review. The review is completed and the review report is compiled. A meeting is offered to the patient. The meeting is held with the patient, and within 5 days of the meeting, the statement in writing is sent to the patient. And again, like Angela mentioned, it's 5 days, not 5 working days. And then we have to record the relevant information as outlined by the Act. In addition, there's a number of sections on the obligations to communicate the process of patient requested reviews. What does it entail? How do you do it? How long will it be? What is the process? What's going to be reviewed? And also there's an obligation to inform patients of their right to request a review. And similar to the sections that Angela has already outlined, there's requirements for a meeting and to who to communicate the review to, the timing and the matters to be addressed prior to the communication, the role of the designated person, the refusal by the patient or the relevant person to participate in the review, the failure to contact the patient or relevant person, additional information, clarification of information, the statement, what is to be included in it and when the statement is to be given, and recording the relevant information. So while the processes are the same for open disclosure of notifiable incidents and the communication of the patient requested screening reviews, they are different events, and the only differences is the processes are the same, it's just that they're actually just two different events. And then finally, as Angela has called out, there is a section regarding the liability insurance for information and apology, and if appropriate, given during the communication of the patient requested reviews. I'm not going to go into them in detail because the processes Angela has already outlined, and as I said before, the only difference is that one is for the notifiable incidents, one is for the patient requested reviews. So finally, the key message at this time is that patient requested reviews are not new to the screening service. Currently, there are processes in place for cervical check and breast check for patients who have developed cancers after screening. There are designated persons available to support the patient in the process, which are designed around the needs of the patient. A process for bowel screen is currently under development. Work is ongoing to identify gaps, the relevant resources and supports for staff, patients and organisations for the implementations of the patient requested reviews as set out in the Act. If your patient has developed cancer after screening and would like a review of their screening, they can contact review.request@screeningservice.ie to learn more about the process. Or alternatively, you can go to our website and there are some more information on the breast check and cervical check process. Now, Marion Daly will discuss the provisions of the clinical audit. And that's all from me.
Hi, good afternoon everyone. Magella Daly here. So very happy to talk to you about the Act as it pertains to clinical audit. So we can just move to the next slide there and we'll get into some level of detail around it for you. So I suppose just at the outset, just to remind people, look, clinical audit is a key quality improvement tool and nothing has changed in relation to it being a key process for ensuring that we're measuring our clinical standards and our clinical guidelines, and our aim is to improve practice and improve patient outcomes as a result of that measurement. What the Act is doing is giving some additional legal protections to staff in terms of how that information from a clinical audit can be used, but it has to be in line with the definition that is in the Act as it pertains to clinical audit, and I'll talk about that in a moment. So in terms of some of the protections that are being added, the new law means that the information created during a clinical audit cannot be used as evidence in legal cases against healthcare professionals. It cannot be used in evidence in disciplinary or fitness to practice procedures against healthcare professionals. So if, for instance, as a result of a local audit in a hospital, it emerged that there was a particular infection rate in a surgical procedure for an individual, that information could not be brought into a disciplinary hearing for that individual in a hospital setting. It cannot be used as evidence to cancel a healthcare professional's insurance. And it cannot be used as an admission of fault by a healthcare organisation or professional. And also in terms of release of information and data from a clinical audit is now protected in that a freedom of information request for individual information from a clinical audit could not be shared as part of that. So it is felt that the benefits of all the protections from the Act will lead to, I suppose, a culture where people feel free to analyse their information, learn from that information and improve within their health services. So it's a protective measure to enable that safe culture to do that. Next slide. So it doesn't seek to alter in any way what you're doing in relation to clinical audits. It's important to note that the legal protections will only apply if clinical audit is conducted in line with the definition of clinical audit as it is set out in the Act. And we already have a clear definition for clinical audit within the HSE, and that's available within our glossary of terms, and I'll pop in the link to that when I'm finished my presentation. And that any clinical audit conducted in line with the best practice guidance as set out within the HSE is also available to you. That is, if you're complying with that, you would be able to have the protections of the Act. And again, I'll pop in the link to that in a couple of moments. Just important to note that all other quality improvement methodologies are not included or affected by the Act, and I suppose there was a lot of consideration around that at the time with the department and with senior clinicians, excuse me, and managers in the HSE. But because of the variety of QI methodologies and activities that are out there in the HSE, it was felt it would not be possible to encompass a clear definition of those for the purposes of the Act. However, it's important to note that all these other methodologies should continue as before. We are developing further and more detailed information around the Act as it pertains to clinical audit, and certainly more information will be made available through the various channels, the HSE webinars and training and education sessions in due course. So happy to take questions in the chat box afterwards that might inform our frequently asked questions documents that we're preparing at the moment. Thank you. I'll hand back to Lorraine.
Thank you, Magella. That's great. So I'm back in the picture, so you know you're on the home stretch. Just a last few points to cover with regards to the legislation. And this section really pertains to the notification to the regulator and some of the amendments to other legislation that I touched on earlier. So the Act is quite clear. It's obviously, as we mentioned, the requirement to notify the regulator, but the means of notifying the regulator are interestingly specified within the Act. And it's in Part 4, Section 30, it specifically says that for the purposes of making a notification to the regulator, the health service provider should make the notification by means of the National Treasury Management Agency Incident Management System. So it's specifically written into the Act. And for a lot of colleagues within the HSE, we would be more familiar with the term NIMS, so the National Incident Management System, that was very much spearheaded by the NTMA, the State Claims Agency initially. And then in Part 9, it will make amendments to the National Treasury Amendment Act, which a lot of our HSE or certainly our public organisations will know specifies that we need to report adverse events that are claims or potential claims to the State Claims Agency. They are inserting this section as well, just again making the link to the system being used for the reporting of notifiable incidents. So again, expanding the scope a little bit there. So importantly, this will also apply not just to the public sector that you need to report it through the system, but it will also apply to the private sector. But there will be some nuances, and some of this is probably taking a little bit of a HSE lens, so bear with me. So for HSE colleagues, I think it's very important to be aware that there's not only the Patient Safety Act that we are trying to implement across the organisations, there's also the National Open Disclosure Framework. So currently for our users within the system, there is already on a field on the NIMS system that asks staff, has open disclosure happened? It's a very broad question. You can say yes or no. And if you say no, then it gives you a little box that you can populate stating why it hasn't happened. With the implementation of the Act and also the framework, there are a number of changes that we want to make to the NIMS, to the system, and specifically around open disclosure. We know, as Angela mentioned earlier, open disclosure is a process. There's some key steps, even stepped out within the legislation, that we want to be able to measure whether or not they've been instigated, whether they've been put in place. So we know through the Patient Safety Act, we need to be able to determine whether a notifiable incident has happened. We need to report it to the regulator via NIMS. We know that that needs to be timely, and that reporting to the regulator needs to be within 7 days of us being satisfied that it has happened. And we will be developing a KPI in terms of measuring our compliance with some of the requirements. Specifically, we'll be looking at whether the open disclosure meeting has happened and whether that's been followed up in writing. And then internally, we'll also be looking at making some improvements just to have that assurance that review reports and that are being shared as well. Importantly, and this is why we're just broadening the scope a little bit on this discussion, is that the National Open Disclosure Framework, which again is applicable to public and private healthcare services, requires health service providers to submit an annual report to the Minister of Health. And within that report, it clearly states out some of the elements that we need to report on with regards to implementation of open disclosure policy, what are our training compliance figures with regards to open disclosure, how many open disclosure leads do we have out in different organizations, and it requires us to report the number of open disclosure events initiated and closed by a health and social care service provider. So importantly, there needs to be a measure, the means of us measuring. So this scope is broader than the 13/14 notifiable incidents that we've discussed through this presentation. So it's really important that we make some improvements in terms of how we capture that data and how that data is populated. So not to go into too much detail, because this is very much a development phase for HSE users. There are a number of ways that staff are currently reporting incidents. There's a paper form, a NERF form, which has a broad open disclosure question on it. Then there's the electronic form, which doesn't have it on the actual reporting form at the moment, but has it later on in some of the review screens. So we're going to make some changes with our colleagues in the State Claims Agency, who very much will be leading on the technical changes to make sure that those high-level open disclosure fields will be available for reporters at the early stages. So whether they are reporting on the paper form, which is already there, or via EPOE through the electronic system, or where some staff currently still transcribing the paper form onto the electronic system, they'll be able to do that much more easily. Then we want to expand on those additional questions with regards to the review screen. So this is for our patient safety incidents, and particularly we want to be able to capture whether the open disclosure meeting has taken place, whether it has been, whether or not the letter or the statement has followed or was sent out following the meeting. And we also want to, within that, capture whether or not any of the exemptions apply, i.e. the patient refused or the relevant person refused, or whether or not we couldn't contact them, bearing in mind that we'd be undertaking reasonable efforts to contact them. And then the endpoint for us, I suppose, with regards to this, we'd also want to capture whether review findings have been shared, whether there was a patient safety incident. Then again, early days, it will be under development, and the aim is that this will all be available and in place and tested with some of our users, that it is workable in time for commencement of the legislation. But importantly, we are linking in a wider kind of project group with the Department of Health, our regulator colleagues, the State Claims Agency, just to ensure that that actual notification function is implemented, developed, and ready to go for when we get the commencement date in terms of the legislation. And Angela talked to you already about some of those very simple questions that the regulators require and as set out under the legislation. So again, I know Angela mentioned it earlier, but within your own organization, you need to determine who is actually going to access the NIMS system and make that notification. So for NIMS users currently, the vision is that you could access the system reported through the notifiable incident fields that will be created, but bearing in mind that obviously the act is for a wider audience, so that private providers can also access a portal, which are very similar fields, but they might have to populate a few more fields that wouldn't be readily extractable as for current NIMS users. I think the only other minor questions that will be added to help obviously our regulators, that the organization will need to provide some contact details, whether that will be an email, and more than likely they will be just seeking confirmation whether an open disclosure meeting had taken place at the time of notification, simply because the feedback from the regulator is that they would be, the first question they would ask you if you report a notifiable incident would be exactly that. So it's just to help bridge that communication a little bit. So certainly there will be further guidance around the NIMS piece. The technical steps need to take place, but there is a lot of work underway with regards to that at the moment. And yeah, we'll be providing more guidance and training once that's been built for all of you. And certainly the regulators and that will be developing some guidance as well in terms of the processes that will follow and the kind of interaction afterwards, because obviously they will be acknowledging receipt of the notification and that as well. And Angela touched on this as well. So if you're looking at the legislation and completeness, you know that we'll all have talked about the 9 different parts within it. Schedule 1 lists the notifiable incidents, and then Schedule 2 elaborates and particularly on the amendments to the Civil Liability Amendment Act to align the language with the Patient Safety Act a little bit further. Okay, that's been quite a broad presentation from all of us. I haven't been able to see the chat, but I know the team have been keeping an eye on it. We're going to take down the slides now and do a little bit of Q&A with regards to the legislation. As we mentioned earlier, this is the first of a number of presentations that we will be doing. So your questions and that will even help prompt us plan the next ones. Certainly the next presentation we do want to run is a bit more from person's different roles and what the act will mean for them in terms of its implementation and certainly the compliance pieces and that. So I think, Angela, you're going to moderate the questions and even respond to some of the questions. Is that right? Or Kelly, are you taking the lead?
These must bring the questions to us, Lorraine, and then as a panel we'll try and respond to as many of them as possible anyway.
Yeah, and just to say, I suppose we're not lawyers, so any of the questions that we can't answer today, you know, we will try and link in. We have some legal support with the implementation as well. So, but we will come back to you if there's any that we can't respond to today.
Great.
Thank you, Kelly, over to you.
Great. So a question that came in, Angela, during your piece, if you could clarify if the Chief Inspector is different to HICWA.
So I understand as the Chief Inspector is part of HICWA, so where the notifications happening is in relation to where is the notifiable instance happened in a designated centre, then that notification will be made to the Chief Inspector. And then in other centres like hospitals, for example, would be notifying into HICWA. Lorraine, is there anything else you'd add to that piece? And then mental health would be the Mental Health Commission, yeah.
Yeah, so I suppose just from the technical piece with regards to the NIMS piece, I know that HICWA colleagues have said that there likely be only the one of two options. So you'll either report to HICWA or the Mental Health Commission, and HICWA will funnel it to the Chief Inspector. So these are just some of the development discussions. So, you know, with the caveat, there will be clear guidance by the time commencement comes, but this is the thinking at the moment. And certainly our regulators have been very supportive in terms of, you know, there won't be a slap on the wrist for us if we maybe make an error initially in reporting it to the wrong regulator, or if we report it under the wrong notifiable incident. You know, there will be some teething problems. They will be providing us with some advice and guidance. I think that should be, you know, that will be a little bit of learning and development as it goes on, but it shouldn't discourage people. The important thing is that we notify the regulator, and there might be some learning along that way.
And I think it's not to be concerned if you report something that you suspect is notifiable incident and it later turns out not to be notifiable incident, not to be concerned about that either. It's still okay to report that or notify the regulator about that. Yeah.
Right.
Yeah.
Thank you. Does the penalty apply to private nursing homes?
So I can cover this as well. So the Act applies to all public and private healthcare providers. So therefore, non-compliance with the Act, the penalties will apply to all private health and social care services as well as public.
Great, thank you.
Can I just add to some of the question there? The penalties actually apply to the health service provider. So if it's not the individual, the clinician may be involved in the case. The penalties is the health service provider who has responsibility around making the open disclosure, the notification to the regulator, and it is also the health service provider who will be penalised, or the penalty will apply to the provider, not the individuals involved in the incident.
Great, thanks, Angela. There's a question in there as well. Are incidents available to the public So that's from the point of view of, you know, any data collected to allow for learning. Will details of the incident be made available?
Yeah, so we do. Like the bigger vision is that we will be in a space where we publish our incident data, and that was a few years down the tracks, and certainly we're making improvements around the data and so forth. We do have a number of projects where we link in with different organizations. We have data sharing agreements and that, but it is sensitive data, so we always have to be very cautious around that. So broadly speaking, we don't publish the data at the moment. We're on a journey to maybe making it more available in terms of, you know, what kind of SREs are being reported, and that we have to be really cautious that they're not identifiable to different organizations, individuals in particular. If you are particularly interested in your, please don't hesitate to get in contact with me or the NIMS team who will funnel that request to me.
Great, Lorraine, thank you. There's a query in just about the information request up to 5 years. So if a person does refuse the open disclosure meeting, can they change their mind during that period, or is the open disclosure period closed?
Again, the Act allows that if a patient or the relevant person initially refuses to engage in open disclosure, they can change their mind under the Act any time within 5 years of their initial refusal, of the date of that initial refusal. So at any time during that 5 years, they can come back to the health service provider and they can ask to have an open disclosure meeting, and the health service provider must hold that open disclosure meeting with them of the notifiable incident, and it will be offence not to do that.
Great.
So the question that could arise there, Kelly, is well, if something came up past the 5 years, there wouldn't be a legal obligation, but certainly we would expect that would be considered, that open disclosure would still happen, but there wouldn't be a legal obligation around it under the Act. Great,
Angela, thanks. So in relation to the written statement provided following the open disclosure meeting, there's a question: is it appropriate to use the meeting template provided? So I'm presuming that means sending the template out following, yeah.
Yeah, and we have a current documentation template that we have that's available on our open disclosure website for dealing with formal open disclosure meetings. And really, the template we're developing for the notifiable incident disclosure meeting is very similar to that template. There's only a few little additions we're adding to it. So that template will be our general template for open disclosure meetings going forward. But as I said earlier, you know, templates can be cold, send them out to a patient. So we really want to, if we're using a template, to send a nice covering letter with that template, where we emphasize the meeting, the reason for the meeting. We reiterate the apology in that letter, and also point them to the details of the designated person. So it really is to not lose that essence of, you know, the empathy and compassion that is required, and then any communications that go out after an open disclosure meeting should really, demonstrate the empathy and compassion towards the patient and the relevant person. So it's really important that the communications sent out, you know, are soft, and that's why we're actually working with patient groups at the moment around the language we're using in those templates. And so again, and really, what the feedback we've had already has been so helpful from patient groups around that.
Yeah. Okay. If a patient has an unexpected dose of radiation that is high level, is this it's a notifiable dose to EPA HICWA, and the question is this a notifiable incident?
Do you want to take that one, Lorraine, as you're covering notifiable incidents? Or?
So I suppose if the patient died, you know, that's how I would interpret it, and it wasn't related to the underlying, because there is that notifiable incident 1.6, so where there is a death of a patient following medical treatment. Certainly, I think radiation treatment would fall within that category, and that's the relatively broad one. That would cover quite a few scenarios, I would feel. So if the patient died, yes. If the patient does not die, then it's not a notifiable incident. For the purposes of this Act, you would still have reporting requirements to HICWA under the radiation reporting requirements.
Great, thanks, Lorraine. I see Magella, thanks, has answered one of the questions in the chat as well, regarding the clinical audit piece and the sharing of information. So thanks, Magella, for putting that in the chat. There's a question in looking for clarification on Section 8 of the Act. So the question is, does Section 8 relate to future notifiable incidents that may be added to the minutes by the Minister? Or is the current list of notifiable incidents broader than those listed in Schedule 1 of the Act?
Well, I think Section 8 currently refers to the current list of notifiable incidents that Lorraine went through, the 1413, which has 2 parts. So I don't think we can comment on any future additions and any amendments to legislation going forward, Lorraine. But currently,
Yeah, well,
yeah.
except that the Minister can add to the list of notifiable incidents, and that will then apply. So again, something we can ask the department, but I would assume that any future notifiable incidents, the Act will apply in full as to the current requirements. But we can take that away as well. That's how I would read it, but we can check it. Yeah.
And of course, Section 8 not only relates to the notifiable incident, but also the failure to hold a Part 5 review meeting as well. So as we went through earlier. Yeah.
I mean, if there was ever an addition, I would expect that there would be quite a bit of comms around it. So colleagues in the health services would be aware of any new requirements under the legislation. Sure.
Okay, thank you. Any idea of the commencement date?
Well, we are working towards the summer, early summer. As you can see from our presentation, there are some key deliverables that need to be in place, not least the technical pieces of the actual reporting to our regulator. But all of that work is underway, and as I touched on, we do have a wider implementation group within the team. Angela and colleagues will be developing an e-learning program, and we have a wider comms plan and so forth as well. So it hasn't shifted from a kind of a May, June anticipated date, but we don't have confirmation, and the reason for that is because of those deliverables that need to be in place. So we're trying to create the momentum for organizations to think, this is what we need to have in place, and I think Angela called out some of those specifically. So you will get a lot of information and comms, and that as soon as we know, you'll know.
Thanks, Lorraine. And there's a question in now just about cooling. So when you have a newborn that has been considered for cooling and the cooling criteria form is filled in, but the infant does not meet the threshold, therefore cooling is not commenced, is this still considered a notifiable incident?
We'll take it to our colleagues within NWIP. I mean, the legislation does talk about if you consider cooling. So again, that might be that's definitely something we can take away to our notifiable incident group in terms of the scenarios. I think if you interpret the legislation literally, it probably would be yes. But maybe if there's some kind of other considerations, we'll take that away. Apologies, I don't have a clear answer. Anybody else have any thoughts on it? No, we'll take it away and we'll take that on board. It's helpful for us when we're developing the notifiable incident guidelines. Thank you.
And we do plan to hold more webinars as well going forward on the Act, and possibly we'll be doing a full webinar on the notifiable incidents once we get all of the clarifications back on those incidents. Yeah. It's probably very likely we'll do that going forward as well.
Great, thanks. And there's a comment in the chat as well. The Act has been welcomed in general, but there's been a number of comments in the press and on social media about inadequacies of the Act. Can the panel discuss these? So I don't know, do you want to just maybe respond to that comment?
Well, I suppose from our perspective within the HSE, we feel that it supports, I suppose, everything we've been trying to achieve. I think we have the advantage of having the office established for a number of years. We have the HSE Open Disclosure Policy. It doesn't conflict with the Open Disclosure Policy. There's some additional requirements. So So I suppose we feel it helps support the kind of bigger implementation. I think for us, the main risk that we want to manage is that people don't hone in on open disclosure for just the notifiable incidents. Our HSE policy is still very clear, you know, particularly where there was moderate harm or above, you do open disclosure. We very much, and Angela can speak to this better, very much making sure that the requirements in terms of empathy, compassion, and carry through. We now have an act, but it's the softer skills that are really important and necessary, and the scope is broader than just the 14 notifiable incidents. Does anybody else want to?
Yeah, I suppose like with any legislation, and particularly when we have the policy, where you get a policy or legislation that actually mandates open disclosure, it's really important. There is a risk that people will start to think open disclosure is only really what's required under the law, as set out in the Patient Safety Act. But it's, as I said earlier, this act is building on our current HSE Open Disclosure policy and requirement to report patient safety incidents under that policy, and particular harm events, you know. And our policy is very clear and gives guidance on harm events and no harm events and the near miss events. So for me, it's really about you know, knowing that this builds on our policy. It doesn't replace our policy going forward, you know.
Yeah, and I think same as the policy, there's a national open disclosure framework that we all need to apply by, and that certainly has a broader scope as well. So I think collectively they all will help support the kind of wider system-wide implementation around open disclosure.
Great, thank you. Would there be regular audits and root cause analysis to try and mitigate, address contributing factors at local and national level?
Yeah, so I suppose where it's where one of the notifiable incidents is a patient safety incident, that would fall in under the incident management framework, and the staff would be undertaking reviews of those incidents. And I suppose audits in particular, we will be, you know, there will be that assurance piece around compliance with the legislation that would support it as well. But obviously, the legislation very much pushes the openness and transparency piece. We have wider remit in terms of making sure that we learn and improve patient safety in that. So it will feed into that, in particular where it's a patient safety incident. Others reviews would be underway.
Thanks, Lorraine. There's just two more questions here, if that's okay. Just back to the template, actually, Angela, I know you mentioned this already. Just HSE hospitals across the country have templates for open disclosure meetings.
Yes, I suppose the templates generally used are templates developed by the National Open Disclosure Office, but other organisations have developed their own templates and stickers actually that they put into the patient record. So basically we have our own template that's on our Open Disclosure website with numerous other resources. I just point everybody on this webinar today to our Open Disclosure webpage. I think Kelly put the link into it there to our resources, and in particular our quick reference guide and toolkit, which contains pre-during and post-disclosure checklist, documentation templates, sample language. There are documentations and templates separate to that on our website, but again, as I said, other services have developed really, really nice open disclosure templates and stickers as well. So if you want more information, just email the Open Disclosure Office and we can point you to some services who've developed their own as well.
Great, I'll put the links in as well. And just the last question here, if a service wants to undertake a review with an associate timeline of 120 days, would this be an acceptable timeline before reporting to HICWA?
No, you have to, as soon as, if you're aware of that, if there's the language in the legislation is that the health service provider needs to be satisfied that the incident has occurred, but like I think we would be quite challenged if our threshold for that would be something as detailed as, you know, maybe coroner's report or whatever. If there's clinical judgment assessment that it's more than likely, I would assume that one of those notifiable incidents has happened, you need to report them to the regulator within 7 days.
And Kelly, I just saw another question there about can the patient record the open disclosure meeting if they request to do so. And the answer to that is there's no laws that prevent a patient from recording their open disclosure meeting. In general, this is why the role of the designated person is really important, that they will help that patient prepare for the meeting, that they will advise the patient that they will be provided with notes of the meeting, like the salient points discussed, and that will be provided to them after the meeting. And if they do wish to record, we would generally say there's no indication why you would not allow a patient or relevant person to record the meeting. The relevant person would really need the consent of the patient. The patient can record because it's their data, but the relevant person would need the consent of the patient to be able to record the meeting. It's really important because in relation to GDPR and confidentiality, people understand that element of it. The other thing is that patients can record meetings unknowns to us, and that does happen. And what we say in relation to open disclosure is that when you're engaged in open disclosure, that you stick to the facts that are available, and you shouldn't get into any areas of speculation or second guessing or surmising. And when you stick to the facts and you engage with that patient in a way that is professional, that is factual, that is empathic and compassionate, there shouldn't be any worries about the recording of the meeting. And in fact, the MPS gives some advice on this, where they said to the Medical Protection Society that recordings can be actually very helpful because they give a very good reflection of what was said at the meeting and how it was said. If a patient requests to have a recording, you could record the meeting yourself and provide a recording to the patient. It's always good to have a recording of the meeting yourself, because we know that recordings can be tampered with as well. So that's the general advice. But really, if a patient asks, sometimes it's just that they're not aware they will get notes of the meeting, and sometimes that satisfies them to know that. And other times they just know that they're not going to remember everything, and a recording is really helpful to them when they go back to speak to their other members of the family about what was discussed at the meeting. So not to get too challenged by these requests for recordings.
That's great. Thank you, Angela and Lorraine. That's I think all the questions. Sorry if I missed any. There's a lot of comments, really good comments in the chat as well. So thanks to everybody for taking the time to do that.
Can I just mention one minor point? So, we're doing a lot of work around the implementation and developing templates and supports and guidance for services. Within the National Open Disclosure Framework, to highlight the importance of having clinical open disclosure managerial champions, which I think within the HSE we're very lucky, there's a really strong network there as well, but also having clinical champions. And I think that for local sites, it's a really important support for when those incidents happen or the notifiable incident happen, that some clinicians might not have much exposure to them, that they can go to a peer who's maybe more confident in that space and actually have that peer-to-peer support available. So I think that's just something for our organisations to think about, what those clinical champions might look like as well. And again, something we'll be writing to you about.
Thanks, Lorraine. So we're getting towards the end of the webinar now. So just to thank everybody who's joined us today. Thank you to all of our panelists I think we're getting lots of good feedback in relation to the presentations were clear, and I think they did give a very good overall insight to the Act, and hopefully we could then go down to a bit more detail going forward in our next webinars. Just to remind everybody that open disclosure training is mandatory for all staff working HSE funded services, and e-learning module 1 is mandatory for all staff, and that's on HSE land. E-learning module 2 should be completed by staff who have to, as part of the role, engage in the formal open disclosure meetings, and those staff should also complete face-to-face training, which you can access by contacting the open disclosure lead for your area, and there's a list of our open disclosure leads on our website. Just moving on, just as we mentioned earlier, we have another webinar just following on from today's topic on what the Patient Safety Act means for me, and we'll be getting various people in various roles talking about the Act from their perspective and what it will mean in relation to their day-to-day work, and that's on the 20th of March at 11 AM to 12:30 PM. And as you're aware, all of our webinars are recorded. This webinar will be available to you. All the webinars are on our website. You'll also get a copy of today's presentation. You'll also receive an email with a short survey, and I see Sandra's put the survey link into the chat there as well. And for our CPD process and for us to give out certs, we do need to complete the evaluation. And again, in today's evaluation, we'll be asking you what questions you have around the Act that maybe we haven't covered, and then if you do put them into the evaluation, we can then build that into our implementation plan going forward. And hopefully you'll all be joining us on our next webinar next month. Just to bring the QPS talk time to your attention as well, on 20th of February from 1 to 2 p.m. And this next talk time is going to be very interesting on the Patient Safety Together community. So I look forward to seeing some of you at that talk time run by our team. And also we work very closely with the HSE consent team. And just to remind everybody about the National Consent Policy 2022 version 1.2. And it's really important. This actually relates very closely to open disclosure, because poor consent processes lead to very difficult discussions when things go wrong. So, so this policy has been updated to incorporate the Decision Making Capacity Act, and it applies to all interventions conducted by, on, or behalf of the HSE. And there's an email address there that you can actually access for more information. And there is HSE National Consent Policy training on HSE Land. And as I say, there is, for more information, there's an email address there that you can use, and that's from the National Office for Human Rights and Equality Policy. So again, we'll just finish up there today. So just say goodbye to everybody. Thanks for attending, and hope you all have a lovely day. And thanks to our interpreters as well, Michael and Kira, and who've been with us. It's hard work doing interpreting for 1.5 hours. So thank you both for contributing today. And it's really important. We're getting lots of really nice feedback from our attendees. They really like the fact that we have our ISL interpreters here. So thank you so much. Your role is very, very important. Thanks, everybody.
Thank you to the panel, and thank you to the team for the organisation behind the scenes. It's really welcome. Well done. Thanks for attending.
Thank you.
Please keep the questions coming in about the actions, various pieces. It helps us.